So I'm going to discuss a little bit more about what I do. I'm going to cheat a little bit. I made a short little list of items that I'll kind of go down through and I'll talk about a little bit. You need an attorney for these topics. I don't suggest Googling it. I don't suggest you trying to figure it out yourself. So many times what happens is a client gets into a situation and they try to get themselves out. And really they start emailing back and forth with the landlord, with the car rental place, with the hotel, with the tenant. And they send, 10, 12 emails and, maybe the last 5 the other person doesn't even respond to. But they really hurt their chances going forward into litigation. I don't do a lot of litigation, but I can definitely team up with a litigator for any business matter. So what happens there is I get all the facts, I get the information, I prepare the case, they go in front of the jury, they actually handle the case, but they're not very familiar with the case. I kind of direct them on how to do it. That's pretty typical in business law. But breach of contracts, right? So if you have a tenant who is violating a contract, talk to an attorney first. Have us send a letter to it. Oftentimes in contracts, there's a notices section, so it needs to be properly addressed and sent to that address, to that client in so many days. Do it properly because you're held to it in court. Employment contracts. One thing that blows a lot of people's mind is non-compete clauses in the state of California usually they're almost never upheld. Okay, so people that are working in California who signed a non-compete, well, you signed that non-compete, but it's really not worth the paper it's written on. But if you believe that something is legal, that you are held to a certain degree, you won't do it, right? If you thought that you had to be at work at 5 and if you took off at 4:30, they could fire you immediately, but that actually wasn't the case. You would stay at work at 5 because you didn't know that wasn't the case. Go to a lawyer. Bring your employment contract to an attorney. See if what's actually agreed to in there is legal. If you have to do it, you'd be surprised. A lot of employers try to really put the noose around employees and keep them on the job and keep them tied down. Same thing, if you're an employer, you should be writing things that are legal. I mean, we can put things that are unconscionable in there, which means unenforceable by the courts. We can put those in there. You can scare your employees, but you need to know what actually will be upheld and won't be. Because if your employee goes to a lawyer and that lawyer tells them that employment contract's a joke, it's a joke. They won't uphold it. So it's really important for employment contracts to get an attorney involved. I had a great success with a client of mine here locally. Confidentiality agreements, those are important. You need to make sure that you abide by it even after you leave that business. You have customer lists if you're an employer that you want to guard. Inner workings of your business, you want to protect those so that somebody doesn't leave to a competitor and just blab all your secrets. Where's your competitive edge? And then write a confidentiality agreement that protects it, right? We all know Microsoft. We all know Apple. There have been a lot of fights back and forth because somebody's an engineer at one, they go to the other, vice versa. Motorola, I think Google purchased them, and they have a really big case right now going against Apple. So that's going to be big in the tablet PC world. Insurance coverage, litigation. So you get in a car accident or you have a construction defect case. I mean, it is key at the very beginning. You get an attorney involved. It can save you a lot of headache going forward. saying simple things like saying I'm sorry at a car accident. Never do it. Okay, swap information, get your attorney involved. You're not being mean, you're not being unkind. It's just what you have to do in the modern world. Okay. Acquisitions, products, services, stuff like that. I write disclaimers for websites, disclaimers to put on packaging. It's very important to understand what needs to be involved there in order to protect yourself, in order to inform the public that something's happening. It's key. But all of these things you need to get an attorney involved with immediately. Can't really do it yourself because we use what are called terms of art. They are words that by themselves mean nothing really, but in the legal world they mean an incredible amount, like unconscionable. That means against thought, I think, originally is the definition. But in the legal world, it means, man, that is so bad that the courts will never enforce that provision. So, for instance, an unconscionable provision in a lease agreement means if you are later than 15 days in making your rent payment, we can come to your house and take your children. Okay, it's in the contract. You sign the contract. The other person signed the contract, but it is so against public policy or the notion of humanity that it's unconscionable. Will never be enforced. That's an extreme chance, but there are others that you need to pay attention to and hire an attorney. So those are some areas that you need an attorney, quite frankly. Thank you.